Hello, I'm Cynthia Quetch with the Missouri Department of Elementary and Secondary Education, the Division of Special Education. This is one in a series of special education training videos. The Individuals with Disabilities Education Act was reauthorized and signed into law on December 3, 2004, and the final federal regulations were published in August of 2006. After the publication of the final federal regulations, the state of Missouri promulgated revised state regulations and revised the Compliance Program Standards and Indicators Manual and numerous other forms. This presentation, the complaint process, is one in a series of training to inform the field of the major changes in state and federal regulations and the implementing changes made in the Compliance Standards and Indicators Manual and the state model forms. There are two forms of complaints, the child complaint and a due process complaint. Any individual or organization who believes that the Individuals with Disabilities Education Act, or the IDEA, has been violated can file a child complaint. The complaint is investigated by the Division of Special Education. For due process complaints, only a parent or the education decision maker or the school district can file a due process complaint. A due process complaint raises issues about a proposal, the refusal to initiate or change the identification, evaluation, or educational placement of a child with a disability, or the provision of a free and appropriate education for the child, FAPE. A due process hearing is conducted by a three-person panel who hears the evidence and makes findings of fact and conclusions of law. Child complaint process. Who can file a complaint? Parents obviously have a concern about their child, but they can also file about any other child. Other individuals can file a complaint about a specific child or a system-wide procedure. How is a complaint filed? The website for the Division of Special Education has a model complaint form. The use of the form is not required, but it contains all of the information needed to begin an investigation. Generally, the name of the child and the school district must be identified, as well as an explanation of the issue. Only issues alleging a violation of the IDEA are investigated. The complainant must also provide a proposed resolution to the problem, and the complaint must be signed. A copy is sent both to DESE and to the district. Why would a party file a complaint? Because they have a concern that the procedures that have not been followed, or they are dissatisfied with the actions of the school district concerning rights under the IDEA. Common issues raised in a complaint include a failure to follow procedural requirements, such as the provision of the safeguards, the failure to provide notice for an IEP meeting, or not timely holding the annual IEP review. Or there may be substantive concerns, such as the services are inappropriate based on the evaluation information and present level performance indicators. The complaint must allege that something has happened within the prior year or it will be time barred. How is the complaint processed? When the complaint is received by the division, a staff member reviews it to determine what issues have been alleged. The staff then frame the issue in the form of the ABC School District, in violation of state and federal regulations implementing the IDEA, has, and the problem is inserted. Sometimes, when attempting to frame the issue, the staff has to call the complainant for clarification. The allegations are phrased in this way to set forth a violation of the IDEA. Allegations that do not concern the IDEA cannot be investigated. Once the allegations are framed, a letter is sent to the complainant acknowledging receipt of the complaint, showing the allegations that will be investigated, and asking for documentation or information to be considered during the investigation. The letter notifies the complainant of the opportunity to participate in mediation. Included with the letter is a copy of the procedural safeguard statement. A letter is also sent to the superintendent of the district informing them of the complaint, offering the opportunity to mediate, and requesting documentation and other information needed to complete the investigation. Because the investigation must be completed within 60 days, districts are given a short time to respond. The investigator collects the documentation from the complainant and the district. Telephone interviews are conducted of the people identified as having information about the issues raised in the allegations. The same person may need to be contacted more than once as the investigation progresses. Oftentimes, someone will be called and asked to respond to statements made by the others. The supervisor may request certain documents to verify or deny statements made by people interviewed. On-site visits are done if they are needed. After the investigator has reviewed the documents and finished the interviews, he or she will draft findings of facts. They always start with the complainant alleged and what the documents provided by the complainant show. Then the findings set forth the response of the district. The investigator then reviews the findings to determine if there has been a violation of the IDEA. The decision portion sets forth the law and then applies the law to the facts. A determination is made whether there has been a violation of the IDEA, and the Commissioner of Education informs the parties whether a school district is found not out of compliance or out of compliance. A separate determination is made for each allegation. Districts found out of compliance must take actions to remedy that violation. Sometimes districts have discovered and remedied a problem before the division investigates the matter. In that case, the Commissioner recognizes that the correction has already been made and no further action is necessary. If a district is found out of compliance, they can be ordered to take corrective action. That may be providing a statement of assurance that the error will not be repeated. If the violation resulted in a denial of FAPE, the district may be ordered to consider and provide, if appropriate, compensatory education. Finally, a district may be told to participate in specific technical assistant activities. The division only makes findings on the allegations alleged in the complaint. Sometimes districts have done more than the IDEA requires, and that extra component has led to the complaint. In those instances, the district is informed in the decision that it is not required to take that extra step. Occasionally, other notes are made about the facts that were found and how a violation could have been avoided. Complaints are to be processed within 60 days of receipt unless an extension of time has been granted. The division generally completes the child complaint process within the 60 days. Extensions are granted only when extenuating circumstances exist, such as the amount of documentation makes a thorough review difficult in 60 days, or crucial witnesses are not available to be interviewed. There is no appeal from a child complaint investigation. Parents or school districts who are dissatisfied with the decision may be able to file a due process complaint. There's no limit on the number of child complaints a party may file. If a party has a pending due process complaint and files a child complaint, the division will look at the issues. If the child complaint alleges issues that are also a part of the due process complaint, those issues will not be investigated as they will be resolved as part of the due process. Following the decision, a satisfaction survey is sent to the parties for input on the process. Mediation as a way to resolve the dispute. When a parent files a complaint, the initial letters from the division to the complainant and the district offer the opportunity for the parties to mediate the dispute. The process is voluntary, and both parties must agree to participate. A list of trained mediators is provided to the parties. The parties agree upon the mediator from the list, and they contact the mediator to ensure their availability. The division then formally notifies the mediator, and the mediator arranges the date, the time, and location of the mediation. The division pays all the expenses of the mediator. Mediation is also available before a party files a due process complaint or after the due process complaint has been filed. If mediation is successful and an agreement is reached, the mediator puts it in writing and sends the agreement to the parties and to the division. A successful mediation resolves the child complaint and the complaint is withdrawn. If the mediation is not successful, the complaint is investigated. If the parties do not comply with the mediated agreement, one of the parties can pursue an enforcement action in court. The due process complaint is a more formal process and is handled by an impartial, three-person hearing panel. Only parents or school districts can file a due process complaint. Under the IDEA, parents is not limited to biological parents, but includes anyone who acts as an educational decision maker. A model form is found on the division's website, but its use is not required. The complaint must be in writing, describe the problem, and set forth a proposed resolution. Only alleged violations of the IDEA will proceed to a hearing. Why do people file due process complaints? A due process complaint can allege a substantive or procedural issue resulting in the denial of FAPE. The complaint must allege a violation that happened within the last 2 years. Parents can file due process complaints when they believe their child has been denied FAPE, they disagree with the placement or services set forth in the IEP, or they want to ensure that their child stays in the current placement when a change has been proposed. When a due process complaint is filed, the child stays put in their current placement pending the outcome of the hearing or until the parents and the district agree to a placement. A district can file a due process complaint to require a parent to consent to an evaluation or to get confirmation that the services they are providing are FAPE. How is the complaint processed? The due process complaint is sent to the division and the other party. The division sends the parent and the district a letter setting forth the process. Each side is asked to pick a hearing officer from a list provided by the division. The party contacts their choice and confirms their availability for the hearing, and then informs the division. The division assigns the chairperson, who is an attorney on contract with the department. Under the new regulations, a party can object to the hearing panel member selected by the other side. A new member will be selected. A party only gets one substitution. Either party can object to the chairperson, and a new one will be appointed. The members of the hearing panel must be impartial. The chairman must be an attorney under contract with the state of Missouri. The chairperson coordinates all the procedural aspects of the hearing. The responding party can object to the sufficiency of the complaint within 15 days of receipt. The hearing chairperson then decides if the complaint meets the requirements. When a parent files a complaint, the responding party, the district or the state agency, has 10 days to send a response to the parent explaining why they took or refused to take the action which is the subject of the complaint, describing other options that were considered and the reasons they were rejected, and describing the evaluation process or other information that was the basis of the action and other factors that were relevant to the decision. In addition, the party who did not file the complaint has 10 days to respond to the complainant, specifically addressing the issues in the complaint. Within 15 days of receiving a parent's due process complaint, the district must convene a meeting with the parent, the IEP team members with knowledge of the facts in the complaint, and a representative of the district with decision-making authority to discuss the complaint and the facts underlying the complaint and to give the district an opportunity to resolve the issue. If no resolution is reached within 30 days, the hearing may occur. If resolution is achieved at the meeting, the parties enter into a legally binding agreement that is signed by the parent and the representative of the district with authority to bind the district. This agreement is enforceable in a state or federal court. Either party can void the agreement within 3 business days of the agreement. The parties have an opportunity to mediate a dispute before or after filing a due process complaint. The parties agree on a mediator from a list provided by the division. Mediators are approved by the division after training and demonstrating a knowledge of special education laws and regulations. Mediators must be fair and impartial and free from any conflict of interest. The mediation must be scheduled within 15 days of the selection of the mediator and completed within 30 days of the agreement to mediate. No attorney may be present at a mediation, but a parent can bring a lay advocate. No more than 3 persons can accompany each party unless the parties agree on more. If agreement is reached, the parties enter into a written agreement that acknowledges that the discussion during mediation is confidential and cannot be used in any subsequent due process hearings. The agreement is enforceable in state or federal court. Due process hearings must be held and the decision mailed within 45 days of either the day of the resolution meeting was waived, the date when the parties determined during the 30-day resolution or mediation period that no agreement could be reached, or when a party withdraws from mediation. Within 7 days of the start of the 45-day timeline, a pre-hearing conference must be held. The chairperson handles the conference, which may be in person or by telephone. Within 5 days of the conference, the chairperson issues a scheduling order. The chairperson establishes the management, control, and location of the hearing to ensure that the hearing will be fair and efficient. The time each party will have to present the case is determined. The hearing should generally last no more than 2 days unless there are extraordinary circumstances. Good cause must be shown for a hearing to exceed 5 days. At the pre-hearing conference, the parties will agree upon written exhibits and witnesses. Issues will be identified and frivolous issues eliminated. The parent is not required to have an attorney. When a parent files a due process complaint, the division provides information on obtaining an attorney if the parent is interested. If, prior to the first witness, the chairperson determines there are no issues to be addressed at a due process hearing pursuant to the IDEA, the chairperson shall dismiss the hearing. The chairperson presides over and conducts the hearing, which is held before the 3 panel members. The chair may limit the issues and length of presentations. The parties present their evidence in the form of witnesses and documentation. Parties can cross-examine witnesses. The panel members can question witnesses and request information. Evidence can be kept out of the hearing if it is not disclosed to the other side 5 days before the hearing. A verbatim record is made of the hearing and is available to the parties following the hearing. The decision. The attorney chairperson writes the decision for the panel reflecting the views of the majority. The decision states the issues, includes findings of fact, and a decision on each issue. Final decisions are posted on the division's website without mention of the student's name or other personally identifiable information. A hearing panel can make a decision on the denial of FAPE based on substantive or procedural reasons. However, in order for a violation of a procedural rule to constitute a denial of FAPE, the procedural defect must have impeded the child's right to FAPE, significantly impeded the parent's opportunity to participate in the decision-making process on the provision of FAPE, or caused a deprivation of educational benefit. Any party aggrieved by the decision may bring a civil action in state or federal court. The appeal must be filed within 45 days of the date of the decision. Parents do not need an attorney to represent their interests in court. Maintenance of placement or stay put. Stay put means that a child remains in the placement they were in on the day of the filing of the due process complaint unless the parties agree to a change. If the hearing officer agrees with the parents that a change of placement is appropriate, the change is treated like an agreement to change placement. If the complaint involves an initial application for admission to public school, the child, with the parent's consent, must be placed in public school until the completion of the proceedings. A court can order a change of placement during the stay-put period if a student is a danger to themselves or others. Here is a brief summary of some, but not all, the differences between a child complaint and a due process complaint. Another good reference for an explanation of the complaint process is the Procedural Safeguards Notice, which can be found online on the DESE website. Resources and handouts for each of the presentations in the series can be found at the website set forth on the screen. The Division of Special Education welcomes questions that participants may have about viewing the presentations. Questions can be submitted to the following mailbox, webreplyspe@dese.mo.gov, or by calling the Division of Special Education at 573-751-0699. We hope you enjoyed this series of trainings and find the information useful in your role as an educator, parent, advocate, or other individual interested in the education of children with disabilities. Other topics in this series are Discipline for Children with Disabilities, Data Collection and Reporting Overview, Finance of Special Education, the Special Education Processes and Changes in IDEA, the Complaint Process, Administration of Special Education, Response to Intervention, Early Intervening Services, or Transition. Thank you for taking the time to view the session on the complaint process.